Welcome, everyone, to the Federal Bar Association Key Time Sections, The Rounds, FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald, Programming Chair of the Key Time Section, here with Tejinder Singh, a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
So, Tejinder, no blockbuster decisions lately at the courts of appeals, but a steady stream of FCA actions nonetheless. Let's start with a couple of cases on C2A dismissals where relators continue to seek a circuit that will require an in-person hearing before allowing the government to end the case. Two cases that we're going to look at, both quite different, but the result was the same. The first, U.S. XREL USN4U versus Wolf Creek Federal Services. In that case, the Sixth Circuit says that it will grant dismissal on the briefs alone. And in U.S. XREL Vanderlan versus Jackson HMA, the Fifth Circuit says the same. Tell us about these two cases, Tejinder.
Yeah, they are quite different cases, but they do ultimately end up in the same place. So the case in the Sixth Circuit is one where the district court became very disenchanted with the relator, basically said the relator had lost all credibility and issued what was effectively almost an ultimatum to the government, said, you need to come in here and take this case over, or I'm getting rid of this case. The government thought about it for a while and then decided, okay, we'll come in, but we'll also move to dismiss the case. And so the question was then, did you need to have an in-person hearing to have that? And was the dismissal otherwise valid? Unsurprisingly, the district court thought it was fine to dismiss the case, and the Sixth Circuit agreed, saying, unless you have the sort of indicia that suggests that a valid ground for contesting dismissal might be on the table, something like a constitutional violation, you don't really need to have an in-person hearing or an evidentiary hearing. You can look at the government's justifications on paper, and the court says it was fine for the district court to dismiss in that circumstance. Vanderlan in the Fifth Circuit is a different case. This is not a case where the relator had annoyed the district court or anything like that, but it was a case where the government itself decided that the ongoing FCA action conflicted with its own administrative priorities, specifically its ability to reach resolutions of the underlying matters. And so the government said, we're getting rid of the FCA case so that we can resolve this another way. And the Fifth Circuit again said, yeah, that seems fine. That seems like the type of reason why you have the dismissal authority. So again, the dismissal was permitted.
Okay, on to the 11th Circuit. We had a different kind of relator side loss in Milner versus Baptist Health Montgomery. The relator found that his declined qui tam action was barred by the doctrine of res judicata because his earlier 3730H retaliation claim had been previously dismissed with prejudice. Most relator side counsel, for sure, Tejinder, believe that it's a best practice to file the qui tam and the FCA retaliation claims in the same complaint under seal. But does the Milner qui tam claim involve the same cause of action as his retaliation claim as the 11th Circuit posits?
I think that's a tricky question, but one that's pretty well settled in 11th Circuit precedent anyway. So the two criteria for res judicata to apply are the two cases have to be between the same parties, and they have to have raised substantially the same cause of action. And what the 11th Circuit has held in prior cases is that if cases arise from the same underlying nucleus of operative facts, that's enough, and it is actually held that a False Claims Act retaliation claim that fails on the merits can then bar a qui tam action. The argument to the contrary is pretty intuitive. It's, look, the retaliation claim is about the employment actions that the defendant took toward the specific whistleblower, whereas the fraud claim is about the deceptive conduct the defendant undertook vis-a-vis the government. You're really talking about different sets of facts, but 11th Circuit precedent now is quite clear in saying that's not how they're going to treat it, and they're going to say that qui tam actions are barred by failed retaliation claims. And so as a result, I do think you're right. It is best practices for relators to bring both of those claims together, or to understand that the failure of one may prevent the other one from being brought prospectively.
Next, we have some cases on the eternal question of what exactly the 9B fraud pleading standard requires when an FCA complaint doesn't cite at least one specifically identified claim for payment. This is a subject on which the Supreme Court has flirted with granting cert, but has not yet, in fact, pulled the trigger to Tejinder. So let's talk about U.S. ex rel Vargas versus Lincare, again at the 11th Circuit. The panel sets a high bar, saying that only one alleged scheme out of the four that were pledged showed sufficient indicia of reliability that any fraud claims had actually been submitted. What sort of particularity did the 11th Circuit want to see, Tejinder?
This case arises out of several interrelated schemes that involved giving CPAP machines out along with the battery packs. The issue was that there is no way to bill for the battery packs that was obvious. And so what the defendants did was they billed using the codes that related to ventilator battery packs. But ventilators, unlike CPAP machines, are life-saving equipment. They bill at a much, much, much higher rate. So there was a claim for improper billing, and then there were some other claims, also again relating to the CPAP stuff, waiver of copays, kickbacks, and automatic shipments of supplies. And what the 11th Circuit says is there was enough here to show that they had improperly billed some of the CPAP batteries as ventilator batteries, but not enough to show that they had done any of the other things. And here the 11th Circuit applies what has now become a common standard in Rule 9b cases. It says you can satisfy Rule 9b in an FCA case in one of two ways, either by providing a representative example false claim or by pleading with particularity a scheme to defraud coupled with reliable indicia that claims were actually presented. And what has counted as reliable indicia is something that really has split the circuits. The 11th Circuit takes a relatively narrow view, requiring more or less firsthand knowledge that some billing occurred, even if you don't have the actual bill in your hand. And I actually want to read a little bit from the Vargas decision because I think it has a line that is somewhat striking. So the decision says that Rule 9b requires that a party alleging fraud must state with particularity the circumstances constituting fraud or mistake. General allegations are not enough. An FCA complaint must spell out the fraud in detail. What happened, who did it, when and where it occurred, and how it amounted to fraud. But even that is not enough. The FCA targets false claims, not regulatory violations, internal misconduct, and not abstract theories untethered from payment. So to state a viable FCA claim, a relator must allege not just a scheme, but a scheme that actually led to false claims being submitted to the government, and must do so with particularity. And so here, although the rule says you have to state the circumstances constituting fraud, the 11th Circuit says even that's not enough. You can describe the fraud in all the detail you want. If you don't also have a claim, you're sunk. And the level of particularity or reliability that they require is fairly high in this context. And so here it was met with regard to one claim, but not the remainder.
We also have U.S. ex rel Olsen versus Tenet Healthcare. This from the 6th Circuit. This seemed to be a well-documented complaint with some truly horrific stories about individually identified patients who obviously didn't receive the care for which the government was billed. And yet the panel here also upholds a dismissal on 9b grounds. Tejinder, the relators were doctors who simply don't have access to billing records. What more could they possibly have done to document the fraud than they did in their complaint?
These particular plaintiffs probably couldn't have done that much more. So the three plaintiffs in this case were ER doctors, and they witnessed a practice that's called the boarding of patients. Basically, patients who are eligible potentially for inpatient care, but the hospital is too full, they can't move them to the inpatient wards, are left in the emergency department for days. And their care is billed at the inpatient rate while they are sitting there. And so the question is, is that fraud? Yes, it is, the doctors allege, but they don't have the actual billing records that show how the billing occurred. They know from conversations with others that this is how it's supposed to happen, but they have no firsthand knowledge that this is the case. And so the case is thrown out on the grounds that they don't have enough knowledge. And what the Sixth Circuit does is it says, if you want to clear the bar for Rule 9b and you don't have an actual claim in hand, what we require you to have is firsthand personal knowledge of billing processes. So that was not something that these plaintiffs could have come up with. Now, you could ask the question whether maybe it would have been possible for the plaintiffs to have gotten billing data from the government. That is, to identify the specific examples and then say, hey, government, during your investigation, if you're not going to intervene, can you give us these things? In a lot of courts, that wouldn't be required. In most courts, this claim would have been sufficient. But in the Sixth Circuit, the court says, nope, not enough.
So at this point, Tejinder, the 9b standard for FCA cases, it varies dramatically from circuit to circuit. Is it time for the Supreme Court to weigh in?
I think it's past time. So I think people who have been involved in this space may remember a couple of years ago, I was involved in 3 different cases seeking certiorari on this precise question that went to the Supreme Court simultaneously. One from the Sixth Circuit, one from the 11th Circuit, and one where the defendants petitioned from the 7th Circuit. And so that shows you that both sides of the V thought there was an issue here. The court at the time called for the views of the Solicitor General. The Solicitor General said, you know, we don't really think there's a conflict because every circuit kind of says that what they're doing is looking for reliable indicia that claims were presented, and so there's uniformity. We pointed out in response, and I think correctly, that although the courts are using the same broad words to describe their test, they're not actually doing the same thing. What counts as reliable indicia in one court is discredited uniformly in other circuits, and vice versa. And so there are cases that are factually indistinguishable that are being resolved differently based on where they are brought. And so I do think that this case was a strong candidate for Supreme Court review 2 years ago. I don't think anything has changed in the law that has made it less attractive for Supreme Court review. And I do think that something's got to give at some point, or these differences will continue to be acute.
Finally, Tejinder, 2 pieces of news from the U.S. Department of Justice. So last year, the department's criminal division launched a pilot program offering awards to individual whistleblowers who provide information that leads to a recovery of $1 million or more in certain types of prosecution. Then the Trump administration arrived. We thought that maybe the new criminal whistleblower awards program would maybe just wither away. But on May 12th, we learned the opposite is true. The department is expanding the Criminal Whistleblower Awards program to cover additional categories. There are already some possible overlap categories here with the Civil False Claims Act reward statute, and now there seem to be more. What are some of the possibilities on how the DOJ might handle this overlap, Tejinder?
Well, the DOJ is going to have to decide whether somebody who is eligible for an award under the False Claims Act or another whistleblower program is also eligible for an award under the criminal whistleblower program. And I think the considerations that are going to animate the DOJ's determination are really policy ones. That is to say, do we want to encourage whistleblowers? Do we want to, or do we fear the possibility of double recoveries? And so I think what they might try to do is find a way to thread a needle that balances these considerations in some way that, you know, gets them to a good outcome. That is, that doesn't discourage people from either filing qui tam actions or making criminal tips, but simultaneously doesn't award unwarranted windfalls to somebody for giving the same information to 3 different sources, you know, and then claiming some double or triple recovery. I think the administration is in the process of figuring this out, but for now, the headline news for everybody watching along is that the criminal whistleblower program has been pretty substantially expanded. And so it's worth looking at the memo that was issued on May 12th by the Department of Justice, which spells out the categories where it applies and the rules that could govern whistleblower awards to the program.
The administration also recently announced that it will use the False Claims Act against Harvard University to address illegal affirmative action and anti-Semitism. What's the current state of affairs here? What's going on, Tejinder?
Yeah, so there was a flurry of news articles about this starting around May 14th and then going through the present, where the Department of Justice has sent a letter to Harvard University saying, look, we're investigating you. We want you to give us all these documents about whether you've broken the law vis-a-vis affirmative action and your response to anti-Semitism, and has specifically flagged the False Claims Act as an enforcement option for going after the university. Of course, the administration and the university are in an ongoing fight, and so this False Claims Act thing is one chapter in it. As of now, no qui tam action or official government action has been filed, at least not on a public docket. But it looks like there is an ongoing investigation, and I would expect it to be pretty hotly contested.
So what are the implications for other False Claims Act cases in the pipeline?
I think there are a few. The first one is that obviously we hear time and again the government's resources are finite, and so some resources are going to this that potentially would have gone to other things. Obviously, the administration has made the decision that that's a priority for it, and that's its right to do so, but it will result in some trade-offs of attention and resources, I am sure. More broadly, this case echoes themes that we've seen in other FCA actions. There have been FCA actions brought against universities for the abuse of grant funding. There have been FCA actions that are brought based on violations of conditions of funding, which can include compliance with things like civil rights laws. And so I would expect that if this case makes law prospectively, that the law made could have effects on cases involving universities, cases involving conditions on the receipt of funds, or the case may ultimately really be about its particular facts. Was there scienter? Were there really violations? That may be mostly what's going on. It's a little early to say, but there are certainly potential implications for lots of areas of enforcement. So this is a case that we'll watch quite closely.
Tejinder, thank you. And thanks to each of you for joining us for this episode of the Federal Bar Association Qui Tam Sections, The Rounds, FCA News with Tejinder Singh. We'll see you next time.